I'm Representative Chris Pearson, and I'm delighted to be joined today by Representative Tony Klein, representing East Montpelier.
And Middlesex.
And in this role here, because he's the chair, or because he's kind enough to help me out, but he's the chair of Natural Resources and Energy.
Correct.
And I was just
in
hoping...
the House.
In the House, excuse me. And I was hoping just to talk to you about Vermont Yankee and the decision we got from Judge Murtha yesterday. Just kind of tell us what it means. Tell me what does this mean for Vermont?
Well, I think we're still trying to
figure
out what it really means. I think to a lot of us, probably including you, Chris, because you've been involved in this for a long time, we're not really surprised by the decision. I don't think any of us who have been fighting long and hard to close these plants down forever have ever expected any of our federal courts to have the absolute guts to say no to this industry and these corporations. So maybe the surprise was on the level of disappointed that it was a Vermont judge that did it to us. I'm kind of disappointed and I'm not a lawyer, but for some strange reason, I read 104 pages last night, and I was really struck by what was allowed to be considered evidence in terms of what our thinking was. What I think really misses the boat is that we may be legislators, but we're Vermonters, and we are Americans, and we have freedom of speech, and we can really say what we want. What we can't do as legislators is create legislation that has anything to do and involving safety, radiological safety around these plants. And the clear fact is that we can say whatever we want in committee, on the floor of the House, on the floor of the Senate, but it's the piece of legislation that we're voting on that is the true litmus test, and I think that's what we really failed in this case. And the other interesting fact is that they cited all these statements from unnamed legislators, referring to safety. I'm told that one of the statements have been attributed to a previous representative from Vernon, who spoke of safety on the floor of the House in a vote explanation, and therefore, poisons the record.
And a supporter of Yankees. So,
exactly.
So as though all you had to do was bring up safety once somewhere along the lines, and just to catch people up. So Vermont, I mean, it's very clear that federal law has jurisdiction over the question of nuclear safety. And so we in this body worked very hard, and particularly in the Senate, which was the body that voted on it, worked hard to not base our decision on the question of safety. Is that fair to say?
That is very fair to say.
And what as my understanding, correct me if I'm wrong, the judge played all these tapes of committee hearings, and any time any legislator mentioned the word safety, it was as though we could only, therefore, ever make a decision based on safety. Well, like anybody making decisions for your family or for at any level, you make decisions for all sorts of reasons. And if you maybe were concerned about safety on Monday, that doesn't mean by Wednesday you haven't figured that there are many things to look at, and that is pretty discouraging.
And as long as you're not shaping, as long as the legislation that you're voting that becomes statute is not about safety, it doesn't matter what you talked about.
Though the judge felt otherwise. Let me ask you something else that I don't understand yet, but was it in 2002 and then reaffirmed in 2006 or somewhere in that timeline there were memorandums of understanding between the Vermont state government and Entergy that stipulated that in the relicensing question, the Vermont legislature gets to have a say. Is that fairly summarized?
Well, yes.
Well, and so what happened to that?
Okay, so prior to any of this and existing on the books in the 60s was new construction of a nuclear plant needs the permission of the legislature. Since the 80s, long-term storage of high-level radioactive waste would require a vote of the legislature. So you fast forward now to 2005, okay, and where they're running out of storage space
at
Yankee in the wet pool because they're now operating in 120% of their capacity. And so they came to us and they said, we need permission to have on-site storage out of the wet pool so we can just get to 2012, okay?
Right.
So we negotiated an agreement to allow that because, number one, we thought dry cask storage was a better way to store that. Well, now I can say, because we all thought it was smarter and safer, for God's sakes, than having it exposed, in a swimming pool on the 7th story of an exposed building.
Charming, okay.
So we allowed for that, okay? And in return, we got guarantees and some payments in the Clean Energy Development Fund. The next year we came back and we realized that, geez, we still have on the books, because we knew that they were going to ask for for relicensing. They're going to have to get approval from the legislature for extended CPG, and they're also going to have a vote of the legislature for long-term storage, on-site long-term storage going forward after that. So we said, well, let's be nice. And say, well, if we'll say if we're going to approve their continued operation, then therefore we're approving on-site storage. So we'll combine the two votes into one. So that's how we got to where we are.
Nice guys finish last in this case.
Absolutely.
Well, where do we go from here? It's clearly nobody I've talked to since hearing the judgment says that it's over. There's appeals, but then there are also other avenues of state law that's clearly within our jurisdiction.
Yeah, let's talk about the good news.
Yeah, please.
Okay, so the good news is that it is very clear that the state of Vermont retains regulatory oversight over continued operation of the plant, and lots of other factors that are involved around that. They have to get a CPG to continue to operate. So that is clearly the good news for now.
For now.
Being the skeptical pessimist that I probably am, I look at the situation and I look at all the generators in this state that have been issued CPGs. Every one of them supplies electricity to Vermonters in some way, shape, or form. And I also know that their continued operation docket, which is started 18 months or 2 years ago, and had extensive testimony on a whole variety of things. The key missing ingredient and why it then became dormant was that there was no purchase power agreement. Okay,
right.
I have on record in our committee as recently as 2 weeks ago from CVPS that no way, shape, or form was it anything that the legislature did or did not do that got in the way of their ability to negotiate or try and achieve an acceptable contract between our utilities and Entergy. They didn't agree to a contract because they couldn't agree on price,
So real
period.
Real
basic
stuff.
And the reality of it is that our utilities have now contracted with our neighboring plant, Seabrook, at a price that was much lower than what Entergy
So the question is, what does the Public Service Board do, given that part of their calculation usually has to do with rates? Well, you're giving us a favorable rate, so we'll weigh some of that. And now, hey, we don't need your power, so they have a whole different set of criteria to look at.
So when I push that out in my mind, I say, well, I would predict that the PSB will say no to a CPG. Well, what happens then? They sue.
They sue. But Judge Murtha says you go to the Public Service Board. That's an appropriate entity, which is.
But he began to collar it by saying You can't use a market or below market price as a reason to not issue a CPG. Yeah. But that's assuming that there's a contract brought. Yeah. In my opinion, that's assuming that there's a contract brought before the PSB. PSB looks at it and rejects it because it's not low enough. There is no contract being brought before them. So what do they do? Huh. And just to be clear for your viewers, that's also interesting. Governor Douglas' administration, which favors, if possible, favored the continued operation of the plant. Okay, by the end of their term in office, they were not happy with the owners of this plant, and their official position filed with the Public Service Board is to oppose the continued operation of it because there is no purchase power agreement.
And that's particularly relevant because members sitting on the Public Service Board are Douglas appointees. Am I right in that?
Every one of them.
Every one of them. So, wow. Okay. Hey, thank you. You've given us a brief but very in-depth overview. Representative Klein,
hey,
thank you very much.
Thanks a lot.
Keep up the good work.
Good to work with you.
Thanks.
Yeah.